Please be seated. Veuillez vous asseoir.
Thank you very much. Welcome back, everyone. What we will do now is we will give the floor to Council for Côte d'Ivoire now so they can make their submissions, and then during the response time everybody would have an opportunity to react to any submissions of interest they make. So we will take submissions from Council for Côte d'Ivoire. Council?
Monsieur le Président, Mesdames, Messieurs les juges,
Mr. President, Your Honors, the team of lawyers representing Côte d'Ivoire, pursuant to a decision from the Minister of Justice, has entrusted this matter to Mr. Jean-Pierre Mignard for reasons of efficiency, and thus it is Maître Mignard who shall address the court. Mr. President, Your Honors, I am very honored on behalf of my colleagues to have this opportunity to deal with 5 points. First of all, the very substance of Côte d'Ivoire's remarks in relation to these proceedings, the necessary representation of Mr. Gbagbo under the conditions set by the court, and in the interests of sound administration of justice, in other words, the necessary protection of victims and witnesses. We will speak to the lack of deprivation of civil and political rights that have been argued by Mr. Gbagbo, and finally, the absolute necessity to meet the requirements of justice and reconciliation which are to be found in the mandate that you have been entrusted with. We make these remarks because this is an unique opportunity to remind the court that it was after Mr. Gbagbo and his supporters' refusal to accept their defeat on the 2nd of December 2010 and to comply with Ivorian constitutional law, it was then that a very long conflict emerged in Côte d'Ivoire. And I can tell you, furthermore, that the Côte d'Ivoire, it has been said that Côte d'Ivoire has been acting in the back corridors of this trial, which is not true. Allow me to move on to the decision by Mr. Bakayoto, the president of the Independent Electoral Commission, who designated Mr. Ouattara as the victor in the election. This outcome was announced by him and recognized by the UN Security Council and by the ECOWAS, by the Peace and Security Council of the African Union on the 10th of March 2011, by the European Union on the 4th of December 2010. All of these organizations are made up of states that, in the vast majority, had diplomatic representatives in Côte d'Ivoire and thus were in a position to observe the events that occurred. In Resolution 1975, 30 March 2011, the UN Security Council called upon everyone. They urged all parties and other stakeholders to respect the will of the people and the election of Alassane Ouattara as president of Côte d'Ivoire, as recognized by ECOWAS, the African Union, and the rest of the international community. All the same, serious, ongoing acts of violence occurred, constituting crimes against humanity, occurred for 5 months in Abidjan and elsewhere in the country, thus blocking the democratic process. The price that was paid was a civil war that claimed a great many lives on each side of the conflict. On the 13th of April 2011, Mr. Choi Yong-jin, the United Nations Security General's Special Representative and the head of operations at of the UN in Côte d'Ivoire stated before the Security Council that the election was one of the world's most open, free, fair, and transparent election, which took place in Côte d'Ivoire on the 28th of November 2010. And the election has been forfeited to the greed of the outgoing president, Mr. Laurent Gbagbo. An utterly unnecessary post-electoral crisis erupted, lasting more than 4 months. Given this these highly serious events, by way of Resolution 1625, the Human Rights Council echoed several member states and set up an independent international commission of inquiry to look into the facts and circumstances surrounding the allegations of serious abuses and violations of human rights committed in Côte d'Ivoire following the presidential election of 28 November 2010. Ms. Pilet, the High Commissioner for Human Rights at the time, said on the 8th of April 2011, after the outcome of the elections were known, she said, we saw shocking violations of rights. We saw the shelling of the market, the murder of women who were demonstrating peacefully, the use of heavy weaponry against civilians, countless acts of violence, looting, extrajudicial executions, abductions, forced disappearances, and calls for violence over the state television. She concluded that some of the violent acts could constitute crimes against humanity. On the 30th of March 2011, the Security Council came to the same conclusions in Resolution 1975, and I quote, "The attacks currently taking place in Côte d'Ivoire against the civilian population could amount to crimes against humanity, and the perpetrators of such crimes must be held accountable under international law," and noting that the ICC may decide on its jurisdiction over the situation in Côte d'Ivoire on the basis of Article 12, Paragraph 3 of the Rome Statute. On the 8th of April 2011, the High Commissioner stated, "The top priority is to do everything possible to end the violence, to halt any violations or murders. And it's also important to end impunity in Côte d'Ivoire." Thus, the President's commitment to punish those responsible for all of these horrific crimes that have occurred in Côte d'Ivoire, independent of whoever they may support politically, and to make a serious effort to come to reconciliation in this highly divided country is necessary. And this is why the High Commissioner asked President Ouattara to ensure that those responsible for the violence would be brought to justice in a sovereign matter, in a completely independent fashion. During that very long period of time, the Republic of Côte d'Ivoire has done everything it could to cooperate transparently and faithfully in relation to the proceedings before the ICC. It must be said, Mr. President, your honors, that the pre-trial chamber confirmed 4 crimes against humanity standing in the name of Mr. Gbagbo: murder of at least 160 people, rape of at least 38 people, other inhumane acts causing great suffering or serious injury to body, or attempted murder, or in relation to at least 118 people, persecution of at least 360 people for political.
One second.
Oui, yes.
You know you had 20 minutes of submissions and you have about 12 left, just so you know. But continue.
Ce qui me permettra, Monsieur le Président,
Council for Côte d'Ivoire. Yes, you are familiar already with the many acts of violence that were committed by the FDO under the responsibility of Mr. Gbagbo or people close to him. Now, the Republic of Côte d'Ivoire wishes to state that the legitimacy of a decision of a court can only come after all charges have been considered, after all witnesses have been heard, after all testimonies have been confronted against one another, but that is not the case. The charges remain despite the acquittal, which is currently the subject of appeal. We have there is no change that would, in the interest of proper administration of justice, Mr. Gbagbo should remain present at trial. And this morning we heard a discussion about the concept of presence. It is not so much a matter of presence in the sense of what the drafters thought, but rather he must be present so he can answer questions put to him. He must be present to be confronted with the testimony of witnesses so that he also can defend himself, so that your decision, no matter what it may be, will be entirely legitimate in the eyes of all. And on this point, we stress so that this trial go to the very end. The principle of equality of arms is at the very heart of judicial proceedings before the court. This means that you can't have half of a trial. Justice is forever and must go to the very end. Mr. Gbagbo, if released, may make good use of his freedom, and he may say he will attend. But what do we know? What can we count on? The protestations of someone who says he will attend. But in some cases, there are suspects who are still at large. And as you know quite well, the court does not have the means to apprehend them. So, right now, Mr. Gbagbo is free. Conditional release without the right to comment upon his trial, which is quite a common state of affairs in many domestic jurisdictions. He can receive visitors well beyond his circle of family and friends. He can receive political friends and the like. He is still under the responsibility of the court, and he can defend himself. And ultimately, Your Honors, no matter what the decision, that decision is up to you. The decision that you take will be completely sovereign, completely yours. If Mr. Gbagbo is put on trial and found guilty, it is necessary that the people of Côte d'Ivoire who have suffered so much must be able to say the trial was legitimate. The trial went to the very end. If Mr. Gbagbo is acquitted, in that case, he must be able to go back to Côte d'Ivoire and people will say, yes, the trial was legitimate. No reconciliation is possible in this country that has suffered so much unless there is reconciliation. And that reconciliation is so dependent on your decision. No half trial. The trial must run its full course. The Republic of Côte d'Ivoire finds itself in a particular position, and as you can see, it's a very firm decision. We support your ruling of the 1st of February 2019. The Republic of Côte d'Ivoire will continue to cooperate with the court as it has done in the past. And ultimately, calm shall prevail. And just one quote, one very fine sentence.
As a united people, for national reconciliation, for nation building, for the birth of a new world, let there be justice for all. Let there be peace for all. Voilà le message moral, spirituel.
So this is the moral, legal, and spiritual message of the Republic of Côte d'Ivoire. This is the message we wanted to transmit to you, Your Honors. Thank you for listening to our arguments, and I believe this is a first. I don't know if this will be the last, but in any event, thank you for allowing us to address the court.
Thank you very much. Now we will take the response submissions from replies from Mr. Gbagbo's counsel first.
Merci, Monsieur le Président.
Mr. Gbagbo, thank you, Mr. President. I have a question to put to you. First, a question of organization. Initially, we were supposed to be allowed 10 minutes to respond to the prosecutor and the LRP, and then 15 minutes to Côte d'Ivoire. So, do you want us to go directly to the observations of Côte d'Ivoire, which will be done by the co-counsel, or do we begin with the 10 minutes to contribute to the discussion that was ongoing a short while ago?
Thank you. That's a very thank you for that question. Yes, we were trying to combine the submission so we don't need to have two split proceedings. So you will now address both. So we will give you extended time. So it's up to you whether you want to reply to counsel for Côte d'Ivoire first or the prosecution first, but you would have enough time to deal with both, since we've rolled up both formats together.
Mr. Oti. Thank you, Mr. President.
Alors nous allons commencer par répondre
We will begin
sur la Côte d'Ivoire et nous continuerons dans la
with the observations of Côte d'Ivoire, and as you suggest, we will continue to the other questions, and it will be Professor Jacobs who will begin. It will be Professor Jacobs who will deal with that second part.
Monsieur le Président,
Ms. Nauri, Mr. President, Your Honors, the representatives of Côte d'Ivoire are here because on the 20th of December 2019, your chamber authorized them to participate in the proceedings, not as a party and not as a participant, but as amicus curiae, that is, a friend of the court. What is a friend of the court? A friend of the court is someone who provides the judges, parties, and participants specific and useful elements that are useful to the resolution of a specific point currently under discussion. This presupposes that the friend of the court has some expertise or some specific knowledge. That is why they are legitimate. A friend of the court should limit themselves to the scope of his or her expertise, or they are no longer a friend of the court. A fortiori, they must not interfere in the proceedings or appropriate the role of a party or a participant, which they are not. And yet, be it in the written or oral submissions of Côte d'Ivoire, I did not hear anything, not a single argument that may help the court to settle the question under discussion. The question is as follows. Is it possible to limit in a drastic manner and over a long period of time the fundamental rights of a person who has been acquitted of all charges? The reality is that from the observations, written and oral, of Côte d'Ivoire, it becomes very clear that they are supposed to oppose the freedom of Laurent Gbagbo and transfer themselves into a party or or participant. These observations do not add anything to the fundamental issue of the restitution of Laurent Gbagbo. Let us look at a few useful elements from the judicial aspect. The analysis of the observations of Côte d'Ivoire shows that they do not have any useful point to provide to the court. Amongst the examples of errors of incomprehension, I'll deal with the no case to answer motion and the appeal procedure. For example, the statement of the Côte d'Ivoire reveals their ignorance of the no case to answer procedure, which led to the acquittal. And that is why in paragraph 16 they said the prosecutor was not in a position to present the entirety of all the incriminating evidence before the chamber, the trial chamber. About 50 witnesses were not heard. And in fact, the presentation of the incriminating evidence was prematurely terminated following the no case to answer notion granted by the chamber. This argument was done today on page 77. Some of these observations are quite simply flabbergasting. The prosecutor presented his evidence for 2 whole years. They were able to present their case freely as they wanted, and they presented all the evidence that they felt necessary to support the accusation against Mr. Gbagbo. Not only did they have the possibility of presenting their evidence, they summarized it in 2 documents, MTB 364 pages and about 1,000 pages in response to our answer. If the witnesses that were initially due to arrive did not come, it was because the prosecutor did not call them. Regarding the no case to answer, it was submitted only after the end of the presentation of the prosecution evidence. So when you look at all the evidence of the prosecution, it was only after that that the chamber fully acquitted Mr. Gbagbo. To state, as Côte d'Ivoire has said, that the chamber interrupted the presentation of the prosecution case, paragraph 17, makes no sense. And in paragraph this...
Let's watch the tenor of the submissions, so that even for purposes of public information, so that if your aim is to explain to those who are not familiar with the structure of trials at the ICC, so you explain it to them so that they understand it, not only counsel in the courtroom who may not be regulars at the ICTR, but also the public in Côte d'Ivoire or elsewhere who may be following the proceedings. It is possible to explain that in a language that does not inflame passion. If your point is that it could be that in the submissions of counsel for Côte d'Ivoire, they were proceeding from the premise of how a trial would unfold either in Cote d'Ivoire or in France or in Belgium or elsewhere. You want to explain to them at the ICC rather, at the international tribunals, there's a different format, perhaps the slide. And that's what you're trying to tell them, where the prosecution calls their evidence first and they stop. And then it's up to the defense whether to call or make it no case to answer. That we can do without using certain kinds of language. Thank you.
Ms. Nauri.
D'accord, Monsieur le Président. Le but de l'exercice est de montrer
The purpose of the
d'expliciter la teneur des
exercise
observations
is
versées au sujet de
to
l'affaire.
demonstrate what the observations were, and given the interpretation problems, I will try to adapt my presentation and represent what I intended to tell you. I was talking about paragraphs 18 and 24 of the representatives of Côte d'Ivoire, in which they stated that they have to wait for the presentation of new evidence by the prosecutor of new evidence and new witnesses. This procedure is not what is envisaged. The no case to answer is a technical affair, and it concerns the conditions of the handing down of their decisions. So the prosecution cannot provide new evidence or witnesses at this stage. Another point raised by Côte d'Ivoire, paragraph 18, is the possible conviction of Laurent Gbagbo on appeal. Once again, they do not seem to have grasped the of the procedure, because it is certain that in this procedure cannot end with a conviction, because this is an appeal procedure. So this is an erroneous technical analysis, and the representatives of Côte d'Ivoire are making arguments to prevent Laurent Gbagbo from having back all his rights. There is another example. We note that as friends of the court, they do not provide any relevant information. They simply parrot what the appeals chamber said in 2019, and this does not add any pertinent point on the factual issues. Regarding factual elements, the representatives of Côte d'Ivoire simply provide personal opinions that are not supported. It is exactly the contrary of what is expected from a friend of the court. There is no expertise. For example, they say that the presence of Gbagbo in his country will be a factor of serious disorder. Not only is this a frivolous statement, but it goes against the desires expressed by a large part of the Ivorian civil society, and a great proportion of the Ivorian political class feel that the return of Laurent Gbagbo will lead to pacification and make it possible for a true national reconciliation process to take place. In reality, the real intention of Côte d'Ivoire seems to be to oppose by all means the return of Laurent Gbagbo to his country. Why? Because Alassane Ouattara wishes to clear the way in anticipation of presidential elections scheduled in October 2020. That is why MPs are arrested and imprisoned, political opponents are persecuted, and even Guillaume Soro, his closest ally and former prime minister, was chased out of Cote d'Ivoire. So the sole purpose, the only purpose of this intervention is to prevent Laurent Gbagbo, an Ivorian citizen, to return to his country and to enjoy all their inalienable rights as a man and as a citizen. And that is what they themselves say in the meaning of their intervention in certain pages of their submissions. They are telling us that Laurent Gbagbo is still victim, or rather is still guilty, without any regard to the fact that he has been tried at the International Criminal Court. They are repeating the narrative defended by the supporters of Alassane Ouattara during the post-electoral crisis, narrative taken by the prosecutor in his various documents and containing the charges, and narrative rejected by the trial chamber. So they are trying to oppose the conclusions, and therefore they wish to convince the chamber to convict Laurent Gbagbo. And this is surprising after what Alassane Ouattara said. It was said during this procedure, and I will show you video CIVD 1500042152.
Can you wait a minute, please? Housekeeping. You know, you had a total, your side now, total of 25 minutes because you were supposed to respond to Côte d'Ivoire for 15 minutes. And you've used up the 15 minutes. Now I think you're about 16 or 15 and a half minutes. So, and you had 10 minutes for the main response. So just so you know. So you've got less than 10 minutes. Thank you.
Merci pour cette précision, Monsieur le Président. Et donc, nous allons en effet utiliser un petit peu de ce temps pour montrer la vidéo.
Thank you, Mr. President. And so we will use the rest of the time to show the scheduled video. I would like to ask the court officer to give me control. CIV 15004295 CIV D 15004391, and the time code is 14 minutes 30 to 1504.
Check the level of confidentiality of the video. Is it public or confidential?
Bien sûr, Madame la greffière, c'est une vidéo publique.
It's a public video, Madame Court Officer.
Et la vidéo sera montrée sur Evidence 2, si j'ai bien compris.
The video will be displayed on Evidence 2.
De l'intoxication. Il n'y a jamais
This is intoxication.
du gouvernement ivoirien. Les
They
avocats
have
ivoiriens ont pris une initiative,
never
c'était leur
been
initiative.
a request of the
Nous
Ivorian
n'avons jamais
government.
été associés
The
à cette
Ivorian
initiative
government
des
took an
avocats.
initiative. It
Maintenant,
was
quand on
their
est des
initiative,
avocats,
and we
on
were
a des
never
avocats, ils prennent des
associated with this
initiatives,
initiative
c'est
of
leur
the
droit.
lawyers.
Mais je nous
And
dis,
when
les
you have
questions judiciaires,
lawyers
on s'en
and
mêle
these are
pas. On vous l'a
lawyers,
dit,
they
on le
took their
répète,
initiatives. It is
c'est
their
un
right.
procès qui est en cours.
And
Il y a
these
pas
are
de raison que
judicial
le gouvernement s'en mêle
questions. We
pour
do
dire
not
faites ceci ou faites
interfere.
cela. Donc, c'était
We have
purement de
told you and we
l'intoxication.
repeat,
Le
this
gouvernement
is
n'a
an
pas eu
ongoing
à se
trial
préoccuper.
and there are no reasons for the government to interfere. This has been said, so this is pure intoxication. The government did not preoccupy itself with this situation. We are therefore surprised that the representatives of Côte d'Ivoire are saying precisely the opposite of what Alassane Ouattara, the head of state, said. That is not to interfere with the proceedings of the court. So for all those reasons, we respectfully ask to ignore all these submissions of the representatives of the Côte d'Ivoire. Thank you, Mr. President.
C'est le professeur Jacobs.
Thank you, Mr. President. Mr. Jacobs will now take the floor.
There was a question left over from the prosecution where we ended it. So you will, of course, take that into account and speak to it. In other words, whether the trial could continue by giving a waiver and that sort of thing.
Oui, Monsieur le Président.
Thank you, Mr. President.
Alors, Monsieur le Président,
Mr. President, let me raise a few points relating to what the prosecutor spoke of this morning and what was raised by the legal representative of victims. First, on mistrial, the prosecutor addressed that this morning and said that if the appeal were to be successful, then they would ask for a retrial of Laurent Gbagbo. Now, that is a very surprising position, mindful of what the prosecution said at paragraph 266 of its brief, when she explicitly stated that she was not going to ask for a retrial and a referral to the trial chamber because of defects in the trial, because otherwise the case will be left in the hands of the prosecutor to determine how justice is to be rendered. So there is no need for a new trial here. This is not a small matter. That is the difference between what is contained in the trial brief and what was submitted in court today. If the prosecutor wanted to amend its appeal brief, it should have done so at that time. But at this level, there is a principle that has been put forward in the hearing, and I believe it has no value, Mr. President. The prosecutor tried to muddle things up a little bit by saying that nothing had changed since last February. But indeed, things have changed between February, July, and October 2019. The fact is that, quite simply, in October, September 2019, the written judgment was available to the prosecutor. She had all the information to be able to determine clearly what was contained in the appeals brief, and that was not done. And nothing has changed since then. Therefore, these are not legal reasons that can speak to the change that we observe today. The appeals brief has been available for several months now, but the reasons for this change must be elsewhere. Now, if we understand what the prosecutor is arguing, it would appear that they are asking for these restrictions to be maintained regarding Laurent Gbagbo, regardless of the time frames, so that the proceedings may continue. Particularly, we see that there is no certainty in this matter. And we also observe that in the appeals brief, the prosecutor refers to the Ruto case in this connection. But this decision was issued 4 years ago, Mr. President, Your Honors. And as far as we know, nothing happened in that case. If we're to understand what the prosecutor is saying, it would be that Gbagbo should be held under these conditions for 4 years, maybe more, so that the prosecutor can have time to do a new case or refer the matter back to the trial chamber. After 8 years of detention and 1 year of detention in inhumane conditions in Côte d'Ivoire, Laurent Gbagbo would then be exposed to detention under such conditions eternally, so to speak. And I think that the trial chamber cannot come to such a determination. Now, when it comes to reference to the so-called network, the prosecutor and the legal representatives have deliberately maintained a confusion between the network and supporters. They want the chamber to believe that there is a network. However, all they have placed before the chamber is material indicating that Laurent Gbagbo has supporters. So there is a supposition of an illicit objective which might lead to Laurent Gbagbo's flight, but you are not provided with any material that determines the existence of the network, the so-called network. It has no leader, it has no organization, it has no intent to cause Laurent Gbagbo to abscond. So they are simply talking to you, Your Honors, about political support. The FBI is a legal political party in Côte d'Ivoire, and a significant part of civil society supports Laurent Gbagbo, who is African. President Bédié, former president of Côte d'Ivoire and former political ally of Alassane Ouattara, went to see Laurent Gbagbo to talk about reconciliation. I don't believe that this adds up to what is referred to as a network. Now, according to the prosecutor, Laurent Gbagbo's freedoms should be limited simply because he is a popular man in Côte d'Ivoire, in Africa, and throughout the world. Now, Laurent Gbagbo is a key Ivorian person and is popular across the world, beyond Côte d'Ivoire, and therefore, given that he is such a popular person, the argument is that he should not be given back his rights, and that seems to be the argument of the prosecutor. In fact, it would appear that the argument is that there was no trial, no acquittal, no case to answer. Basically, all the... Thank you. Basically, the reasoning behind all of the prosecutor's arguments this morning and those of the legal representative of victims is that they assume that Mr. Gbagbo is still guilty, and this is at variance with the position of the judges. One last point, quickly. The prosecutor referred to the Masso decision of 2017, arguing that restricting freedoms would fall under Article 2 rather than Article 5 of the European Convention. However, the prosecutor failed to point out to you that there was a matter pertaining to the breach of the rights of the accused in that case, and this matters regardless of the legal foundation of the reasoning. Let me conclude by answering your question, Mr. President. We simply want to point out that Laurent Gbagbo has committed himself in writing to respect any orders from the court, to be present as and when necessary, and to comply with all the conditions in order to ensure that the proceedings unfold smoothly. In that connection, we do not see any particular difficulties. Now, about the legal issue of his presence in the proceedings or in the hearings, this morning you referred to the Rome Statute and the regulations, and the rules rather, and the various possibilities that are open for an individual to be absent from trial as such. But in any event, that question does not arise in this matter because Laurent Gbagbo has committed himself to be present and to comply with all the rulings of the chamber.
That's a different question. There's a specific question now, and that specific question is, in the event that, now this is does not indicate what the appeals chamber will do. In fact, we just want to get all the information to take into account during our deliberations. The question is, in the event that assuming the appeal of the prosecutor succeeds, and that's only an assumption or an argument for purposes of argument, if that happens and the trial has to continue, would the Gbagbo defense or Mr. Gbagbo himself object to the trial continuing if he does not show up as ordered by the court? That's a specific question.
Monsieur le Président, merci.
Thank you, Mr. President.
À ce stade, je ne peux pas vous répondre.
I am not able to provide you with any answer other than Mr. Gbagbo's commitment to be present in court. We have no other theory that we can put forth in this matter.
We'll leave it at that. We note for the record that Mr. Gbagbo is in the courtroom. We'll leave it at that. Thank you. Counsel for Mr. Blé Goudé.
Mr. President, I will first address the observations by the prosecution, also address the question of the prosecution, after which Mr. Nindri, co-counsel, will address the observations of the State of Côte d'Ivoire. Mr. President, the Office of the Prosecution, during their submissions, actually created itself two exceptional circumstances for the Chamber to warrant the reconsideration. I will address them briefly. First, it created an uncertainty as to the future course of these proceedings. Scenario A, there would be a mistrial. The case would be handed to the prosecution, and it's to its discretion to decide its further course. Scenario A. Scenario B, which is also alluded to today, is a mistrial and a retrial. Now, needless to say, Mr. President, that both scenarios will probably take us for many years in this courtroom, if, hypothetically, this course would be followed. Because the prosecution actually asked you to hold your horses and to wait after the appeals judgment on the merits, and then hear from the prosecution what the future course of the proceedings will be. Now, the relevance of this observation is that the length of this prospective trial, if the prosecution scenarios would be followed, either A or B, would take us in a trial for many years. And based on the undue delay clause enshrined in the human rights instruments and also endorsed by the European Court of Human Rights, that in itself creates, for now, an exceptional circumstance. So the prosecution because it's not able to present to this chamber after 9 years of investigation a concrete course of proceedings after 9 years. That in itself is not only worrisome, but creates, as mentioned, in exceptional circumstances. And the prosecution simply assumes that in case of a mistrial, it is without prejudice. But your chamber can, in this hypothesis, decide a mistrial with prejudice. Because the alleged errors the prosecution has put forward in its brief relate to errors allegedly done by the judges, i.e., the time limit for the written decision, the judgment, and the second appeal ground, the standard of proof. It had nothing to do with interference in proceedings on part of the accused persons. It has nothing to do with the endangerment of the integrity of the proceedings, which is normally akin to a mistrial, Mr. President. So let us assume you follow the path of the prosecution. You could even determine a mistrial with prejudice. And this might also include the situation that the case ends there. I'm saying this not to say that this course is to be enrolled, but to say to your chamber that in light of the uncertainty of the future course of this trial and its prospective length, the chamber is confronted with now an exceptional circumstance, because the prosecution today creates this scenario B, while in the appeal brief in paragraph 266, it creates scenario A. The second creation by the prosecution of an exceptional circumstances relates to the concept of a mistrial. Actually, we have hoped for that discussion during the merits of the appeal, but now we also as defense forced to go into the concept of mistrial in light of the existence of special circumstances. Mr. President, the Supreme Court of the United States in 1978, in the case of Arizona versus Washington, a landmark case, ruled that the double jeopardy clause protects defendants from prosecution who try to use mistrials as an opportunistic tool to avoid an acquittal. I think this is an observation we are entitled to make today, because the draft solution the prosecution presents to the chamber in terms of remedy assumes that there were reasons for a mistrial. Well, we all know from the Ruto and Sang case that this concept does not apply here automatically. The basic forensic premises for a no case to answer were met, unlike Ruto and Sang, as you yourself, Mr. President, ruled in paragraph 139 of your opinion. Unlike Ruto Sang, the chamber, in this case, was able to come to a final disposition of the case. It acquitted Mr. Blé Goudé, Mr. Gbagbo, after a thorough evaluation of the evidence, after which it determined that the case was so weak to make a defense case unwarranted. There was no issue of interference, of tampering witnesses. The forensic premises for a no case to answer were met, Mr. President. It's very clear. But I mean, if the prosecution asks the court now for a mistrial, it would render actually null and void the protection of Article 20 of the statute. If granted, it would preclude Mr. Blé Goudé from asserting that he was already being tried and acquitted of the crimes under Article 20. In other words, the argument of a mistrial with the prospect of a retrial, it's really a question whether this chamber, when it will go to the merits of the case, will follow this option. We are not yet at the appeal stage, but now the prosecution has alluded to it during its submissions. We say that this actually contradicts exceptional circumstance, the absence thereof, by the prosecution. I note here that in the landmark book of Professor Trifterer and Professor Ambos, the Rome Statute of the International Criminal Court, a commentary, 3rd edition, page 645, is being discussed whether a trial chamber judgment on the merits may suffice to trigger ne bis in idem. And they answer that question in the affirmative.
Now, Counsel, I have no question for you. Just do not forget to give either now or later the reference to the
yes,
to the Arizona and Washington case you mentioned.
Yes, we will. Yeah. So first, this is an argument to say the argument of the prosecution of a mistrial and the analysis on its face whether this is a valuable legal concept here warrants the acceptance of exceptional circumstances. Because clearly the conditions for mistrial are not met. Secondly, even if the court would follow scenario A or B of the prosecution and therefore would go along with the mistrial based on mere errors by judges, allegedly errors by judges, are no mistrials. But even let us assume, for the sake of the argument, that the chamber would follow the prosecution reasoning, then still, Mr. President, Article 81, 3C1, I, of the Rome Statute is saying that the conditions are no longer necessary. So even in the prosecution theory, scenario A or B, that article, which is the basis of your judgment of the 1st February, is no longer applicable. Lastly, a mistrial and a retrial, either in scenario A or B. Has the chamber realized that Article 20, Section 3 of the statute would probably preclude a new trial at this court? Mr. Blé Goudé is convicted on the 30th December in absentia. I'm not speaking now about the legality of this judgment. He is convicted. And the Cour de Cassation in Côte d'Ivoire rejected his appeal, also in absentia. That means that scenario A or B of the prosecution will be confronted with the procedural obstacle of Article 20, Section 3 of the Rome Statute. And that means, as a consequence for today, that the prospect of a new trial, either a retrial or the case comes back into the hands of the court, will also probably be confronted with this obstacle. And for today, it means that conditions to may be maintained in this scenario is highly improbable and constitutes an exceptional circumstance. We now know that Mr. Blé Goudé is convicted in Côte d'Ivoire, up to the Supreme Court there for the same facts. The evidence is in the exhibits 8 till 12 we submitted yesterday. All the incidents mentioned in the verdict were tried before this court, Mr. President, everything. Same time slot, post-electoral crisis, the same location, the same subject matter. And if you look at the case law of the European Court of Justice, like the Van Esbroek case of 2006, if you look at the European Court of Human Rights in the case of Zolokten versus Russia, that's authority 7 of our list, you will see that the principle of non-double jeopardy, therefore, would apply. So these are two exceptional circumstances which now have arisen from the submissions of today by the prosecution. Finally, two observations. Is there any need for conditions apart from this whole expose on the mistrial? No, Mr. President. The prosecution said this morning, that's the English transcript, page 50, lines 90 till 20, that there is a risk that Mr. Blé Goudé would flee to a country other than Côte d'Ivoire, which country there would be no extradition treaty. But is the prosecution aware that the Netherlands has no extradition treaty with Côte d'Ivoire?
Now, I want to ask you a question, Counsel, before you proceed. Again, let's keep in mind where we are. We're in open session. I'm mindful of that. You made reference to, or rather, you relied on the process in Côte d'Ivoire, the conviction in Côte d'Ivoire. That's the basis of the argument you made just before your last point. And you were saying that the incidence of that event, to put it colloquially, may have put the prosecutor's theory in difficulty, let's put it that way, that there may be a retrial later. Do we know what the law on trial in absentia is in Côte d'Ivoire? There are some regimes where trial in absentia says an accused person who did not show up after reasonable notice of the proceedings had been given to that person and didn't show up, the trial may proceed in the absence of the person. But if the person comes back and shows that they could not have attended, the trial at home, the trial had to be redone.
Yes.
That's one factor. Again, is that the case? Is that the regime you have out there in Côte d'Ivoire on this question? If that is, does that make a difference to your own analysis? Coupled with the fact that Mr. Blé Goudé was in detention at the ICC, was it, at all times?
Yes.
Okay, keep all that in mind.
Yes. Mr. Lindry will address this question, but I'm not trying to evaluate the legality of this trial in Côte d'Ivoire because I can speak for hours about it. I just say the prosecution simply assumes that the retrial is possible. I say Article 23 might be an obstacle. It's not for now, but the court cannot exclude that a retrial on the current situation would be impossible, apart from the legality of the proceeding. But then it's up to the prosecution to show that the trial didn't meet the standards of international law. Mr. Nindri will address the question on absentia. There is a provision in the Code Pénal de Côte d'Ivoire, and he can explain whether this was met or not. For now, I simply say to the court, this whole hypothesis of the prosecution scenario A or B is a scenario which is so uncertain for the chamber that this creates an exceptional circumstances in terms of the timing of the proceedings and the way these proceedings might continue. Mr. President, last remark, there is no extradition treaty with Côte d'Ivoire and the Netherlands.
Okay, can we...
microphone, Mr. President.
Closed session.
We are back in open session, Mr. President.
Last remark before I give the floor to Mr. Henry. The question of the prosecution and the chamber on the presence of Mr. Blé Goudé.
Definitely. So I'm very interested in that question.
3 observations. First, Article 63(1) does not exclude waivers. It doesn't exclude waiver from defendants not to be present, or vice versa, statements that the court could continue even without his presence.
So your point is that, yes, the proceedings can go ahead if...
Technically they could, because at the ICTY there is a similar provision as Article 63, Section 1, and the practice there that defendants can sign waivers to not appear 1 or 2 days in court if that's for a certain reason. So legally it's possible on the basis of the statement the court has before it that the proceedings could continue. I have to say, though, of course, that the waiver should be voluntarily, because if Mr. Blé Goudé would hypothetically be detained elsewhere, I'm not going to details, then, of course, the waiver to continue would be have to proceed differently. But our submission is that with the statement the court has before it, the proceedings could continue.
And you'll be prepared to give that waiver?
Yes, of course, to secure the proceedings. That's, of course, Mr. Blé Goudé prefers to be present, but and he will be present at all times the court orders so. I'll give the floor to Mr. Henry, who will address the observations of the State of Côte d'Ivoire.
Thank you. You have 5 minutes left. I've been told that you have 8 minutes and not 5. Please proceed.
Bonsoir, Monsieur le Président.
Good evening, Mr. President. Ladies and gentlemen, honorable judges, good evening. Mr. President, I would like to find out whether, when it comes to the question you raised with Maître Knops on the absentia trial process, will that be counted as part of my time, or would it be dealt with separately? Because you put a question on the issue of trial in absentia in Côte d'Ivoire.
Do your best to fit it within your time. Do your best, if you can.
D'accord. Merci, Monsieur le Président.
Let's continue. Very well. Thank you, Mr. President.
Je vais donc aller vite.
Let me proceed
Mes observations sont fondées
expeditiously.
sur
My comments will
les
be based
observations écrites
on the
versées par
written
les avocats de l'État de Côte d'Ivoire
filing of the lawyers of Côte d'Ivoire submitted before today.
va donc m'occuper
I will
du
therefore
exposé qui a été
not
fait
address anything pertaining to the
par l'avocat du
lengthy
représentant de l'État de
presentation that was made by the lawyer for
Sur le
Côte
premier
d'Ivoire in court.
de mes observations.
My first point, by way
Le
of
risque de
remarks,
fuite.
will deal with the
Sur le risque de
flight
fuite.
risk.
Pour justifier leur argument,
In order
sur
to
le risque de
justify their flight risk argument,
avocats de l'État
the
de Côte
lawyers
d'Ivoire
for the state of Côte
ont allégué,
d'Ivoire
et je
alleged,
vais les citer,
and I'm going to quote,
l'appel en cours
that the ongoing
justifie plus
appeal
encore le maintien en liberté sous
justifies even further the need
condition, dans la mesure où
to
le risque de
maintain
condamnation
the
à une
conditions
lourde peine
insofar as a
pourrait
risk
inciter
of
à la
a
fuite.
heavy sentence may lead to flight.
Fin de citation.
End of quote.
Sur ce point, les avocats de
On
M.
this
Blé
point,
Goudé
counsel for Mr. Blé
émettent
Goudé
de très sérieuses
have
réserves
very serious reservations
quant à la pertinence
about the
de cet
relevance
argument.
of this argument.
Et pour nous justifier, nous
And for
avançons
that reason,
les
we
deux points qui suivent.
make the two following
Premièrement.
points. First,
Après une décision d'acquittement
after a decision
prononcée le 15
for acquittal
janvier,
as of
2019,
15 January 2019,
il apparaît pour nous une
it appears
conséquence
to us
juridique
that the natural
et une attitude naturelle,
outcome and consequence
c'est que la
of
personne
such a
acquittée
decision should be
jouisse pleinement
the
de sa
full
liberté
enjoyment
naturelle
of
d'aller
their
et de venir.
freedom by such acquitted person, freedom of movement.
L'hypothèse envisagée d'une fuite dans les conditions que nous connaissons, à savoir
In the conditions that we know,
que le procureur
namely that the prosecutor,
ait fait preuve d'exceptionnelle faiblesse
the
au niveau
prosecutor's evidence was
de ces
exceptionally weak,
versé au dossier.
as demonstrated by the case file.
Tout cela
In
est
those
incompatible
circumstances,
avec
we
l'hypothèse d'une fuite dans ces conditions.
believe that this is incompatible
Puisque M.
with the
Charles Blé
theory
Goudé se trouve
of a
devant
flight
une décision
risk under these circumstances, given that Mr. Blé Goudé has been acquitted,
Décision d'acquittement, et cela est
An
inédit.
acquittal,
Je ne sais pas si au
which
sein de cette
I may
cour,
say is
il y a
unprecedented
eu
because
un
I
tel
don't know
qualificatif en ce qui
whether
concerne les preuves
there was
de l'accusation.
ever any such qualification of evidence
Nous sommes en
before
face
this court
d'une exceptionnelle
as
faiblesse.
being exceptionally weak. So we are dealing here with
Déjà des preuves faibles.
an exceptionally
acquittement.
weak body of
Et
evidence,
lorsqu'on est devant
which
des
led
preuves
to an acquittal.
faibles, qualifiées d'exceptionnelles,
When you are dealing with evidence that has been
pensons que
referred to
l'hypothèse de
as
fuite
exceptionally weak,
est
we
improbable.
believe then that the theory of a possible flight
Deuxième
risk
élément.
is quite unlikely. Secondly,
Et malheureusement, ou je ne sais pas,
and
cela a changé ce
unfortunately,
matin,
this argument seems to have changed from this morning.
cela a changé ce matin, comme par extraordinaire.
Unfortunately, the
On
argument
nous avait
changed suddenly this
parlé
morning
de mistrial,
because
aujourd'hui, nous avons
previously
entendu dire
we were
au
told
procureur
of a mistrial, but today the
qu'il
prosecutor
compte
has
suivre
argued
cette procédure.
that she intends
Ajoutant
to
en notre
continue the
sens
trial,
une incertitude
and this brings further uncertainty into
qui
play,
doit justifier, qui devrait
which
justifier, à
therefore
notre sens,
must lead
que les
to
conditions
our understanding to the finding that the
qui ont été
conditions
portées
which
au bas donc de l'acquittement
were
soient
the
définitivement
reason
levées.
for the acquittal should be lifted.
Dans un deuxième point, je voudrais répondre à l'État de Côte
Secondly,
d'Ivoire. En ce
let
qui
me
concerne
address
le refus de
the
liberté sans condition à cause de la nécessaire
refusal
protection des victimes et des témoins.
of freedom
Cela est
based
contenu
on
dans
an
les
argument
versés
pertaining to
à votre dossier.
victims and witnesses, and
Sur
their
ce point, nous
argument
faisons
is
observer
contained in their filing. On
que
this particular point,
la majorité
we
des
would like to
témoins
point out that most of the witnesses
qui sont arrivés ici et
who
qui ont
appeared
déposé
before this
dans
court
cette salle
and testified
vivent en Côte
in this
d'Ivoire.
courtroom live
et
in
ces
Côte
témoins,
d'Ivoire.
après avoir déposé ici, sont
After
retournés en Côte
testifying
d'Ivoire.
here in the court,
Et
they
aucun de ces
returned
témoins
to Côte d'Ivoire,
n'a fait l'objet
and none
de
of them
pression de qui que ce soit.
has come under any pressure
De telle
from
sorte que
anybody whosoever.
venir ici dans cette salle
That is why
pour avancer l'hypothèse d'une menace chimérique
when the
qui pèserait sur les
idea
témoins
of some
si une personne
fanciful or mythical threat
jouissait de sa liberté,
is argued
pour nous,
as
ce sont
having
des arguments qui ne tiennent pas.
to deal with a particular accused person, we believe that such
Relativement
an
aux
argument against unconditional
On nous a
release
parlé des
does
victimes
not hold.
qui seraient privés de
We have been
réparation
told
du fait
that
d'un acquittement.
victims will be deprived of reparations
Cet argument
because
choque
of
la rigueur
acquittal.
de la pensée juridique.
This kind of argument stands
nous dire
in
pourquoi.
stark contradiction to the
Ce
rigor
que les
of
victimes recherchent,
legal thought, and I
ce
can
n'est pas
tell
un
you
bouc
why.
émissaire.
What the victims are looking for is not a
Ce que les victimes
scapegoat.
recherchent premièrement, ce n'est pas
The
la
first
réparation.
thing that witnesses
Ce
are
qu'une
looking for
victime
is not
recherche,
necessarily
c'est la
reparations. What witnesses are looking for,
Et cette vérité,
is
en notre sens, a
the
été
truth.
dite ici,
and that
dans
truth,
cette cour,
we believe,
le 15 janvier.
was declared here in this courtroom on the 15th of January.
Je pense que l'alternative
I believe,
du
therefore,
vail,
that
c'est que les vrais auteurs,
the only
puisqu'il y a
alternative
victimes,
theory that
effectivement,
would prosper
que les vrais
is that
auteurs
the real
soient
perpetrators, since they were
retrouvés,
victims, the real perpetrators should be sought after, found,
Je finis.
and prosecuted.
sur le point
Let me conclude
la
by
mission de
addressing
justice,
the issue of justice,
un préalable à toute réconciliation.
which is a precondition for
Mais avant d'aborder ce
reconciliation.
point,
But before I address
je
that
voudrais
point,
dire que la possibilité
let
avait
me
été laissée à la
say
représentante légale
that
des
the
victimes
legal representative of victims
d'appeler
had been given
des
the
témoins
opportunity to call
de venir
victims
établir des faits.
to this courtroom to come and speak
Lors de
to
la
the
procédure,
facts during
La
the trial.
représentante légale des victimes a décidé,
The
devant
legal
le monde entier,
representative
devant
for
la
victims
justice, de
decided,
dire qu'elle n'appelait pas
in the presence of all and
de
sundry,
victimes, de témoins ici.
to waive that right
Je pense
to
que l'heure
call
n'est plus à la
victims and
spéculation,
witnesses here.
mais à
So
l'établissement
we
des
can no
faits.
longer
Et cela a
speculate
été
on that matter
l'objet donc
because
de
it is
l'acquittement,
settled,
puisque les faits ont été
and
débattus ici.
the
Je disais
case
que je finissais
led to an
sur
acquittal
la mission de la
based
justice, un
on
préalable à toute
adjudication
réconciliation.
on facts.
Effectivement, nous
Now,
sommes d'accord
coming to the issue of
que
reconciliation,
la justice est un
we do
préalable à toute
agree
réconciliation.
that justice is a precondition for reconciliation. However,
Est-ce que cette justice entend
justice
par
as such
justice qu'on trouve un innocent et que cet innocent-là soit
Should
condamné pour qu'on puisse dire
justice
qu'il y a justice?
lead to the conviction of an innocent person simply because we want to achieve justice?
Monsieur Charles Blé Goudé a été
If that were the
et
case,
82
then there will be no
des
justice.
milliers de
Mr.
pièces
Charles Blé
versées
Goudé
dessus.
was tried, 82 witnesses were called, several documents
est
were
acquitté.
filed, and the judges decided on
En ce
an
qui concerne
acquittal.
maintenant la question que vous avez posée
Now,
sur
coming to the question,
la contumace.
Mr. President,
Effectivement,
of trial in
la
absentia,
contumace est prévue par
this is provided
justice
for
ivoirienne.
in
Dans
the
quelles conditions
legal
est-ce qu'une
system
personne
of Côte d'Ivoire.
peut être jugée par contumace.
But the conditions that apply are as follows.
Your time is technically up, but if you can quickly make that point.
Oui, je vais répondre respectueusement à la question posée par-
Respectfully, Your Honor, I will answer the question that the chamber has raised.
J'ai ici le code de procédure pénale. de
We
Côte
have the
d'Ivoire.
Code of Criminal Procedure in Côte d'Ivoire here, Article 354 of that Criminal Procedure Code answers your question and provides as follows. The accused person who
Sans excuse valable.
may be absent without a
à
valid
l'ouverture de
excuse
l'audience
at
est
the
jugé par contumace.
opening of the trial shall be tried in absentia.
Sans excuse
The
valable.
accused person who is
à
absent
l'ouverture
without
de
a
l'audience
valid reason
jugé
at the
par
opening of the trial shall be tried in absentia.
Sans excuse valable.
So without a valid reason is the condition, and I think it is for the court to determine what that means. Mr. Charles Blé Goudé, in the circumstances at hand, was surrendered to the court by a decision of Côte d'Ivoire, order number 67 of 21 March 2014. He was tried and acquitted. Your decision appended a number of conditions to this acquittal for him to be maintained where he is. And if the Ivorian legal system came to the determination that he was absent without a valid reason, then it is for the court to determine whether or not the Ivorian justice system used this provision for its own purposes. And that will be it. Thank you.
Thank you very much. Now we have time for the prosecutor to respond. 15 minutes, and that is to Côte d'Ivoire submission.
We can be very brief. We could use those 15 minutes to respond to Côte d'Ivoire and also to the other observations that we would want to make in closed session, all in 15 minutes, so we can conclude the hearing today.
Proceed.
And also my colleague, Ms. Narayan, would make one quick observation after I respond to Côte d'Ivoire. So we are responding to the observations of the government of Côte d'Ivoire in the assumption that the council present in the courtroom today have a valid mandate from the government, contrary to the suggestion by the defense of Mr. Laurent Gbagbo. Council have shared a power of attorney with us. It was signed on 20 January 2020, and I'm sure if there is any doubt, Council would be prepared to share that with the court. So the government of Côte d'Ivoire objects to the lifting of Mr. Gbagbo's conditions on release. According to the government, doing so would likely lead to Mr. Gbagbo's return to Côte d'Ivoire. This in turn would create a flight risk and also affect public order in Côte d'Ivoire. Based on these submissions, it appears that Côte d'Ivoire is unable to ensure his appearance for any future proceedings before the court. In these circumstances, and given that you have already found that Mr. Gbagbo has an incentive to abscond, the appeals chamber should not merely rely on Mr. Gbagbo's word that he will appear voluntarily before the court if released to Côte d'Ivoire. Indeed, Côte d'Ivoire's position matches our own, that the appeals chamber should not lift the conditions imposed on Mr. Gbagbo's release. The compelling reasons justifying the conditions imposed by the appeals chamber last year continue to exist today. If these conditions were lifted, Mr. Gbagbo were to travel to Côte d'Ivoire or to a third state, his presence in future proceedings simply could not be secured. I'd now like to give the floor to Ms. Narayan and then come back in closed session.
Thank you very much, Your Honours. I won't take more than a couple of minutes, but with your permission, I'd just like to make a few very brief observations just to clarify a few things about the remedy that we heard just now. First of all, I think it just comes back to paragraph 266 of our appeal brief. So based on a contextual understanding of our brief, and this might go to some of the submissions that Mr. Gbagbo's counsel made, we have not said explicitly that we would not seek a retrial. That is simply not there in the language of paragraph 266. Second, we've asked for the case back. Why else would that be except that future proceedings are still alive as a possibility? Third, and this I would like to read the language of paragraph 266, which acknowledges that you, Your Honours, can order a new trial, which would be a possible remedy. So that possibility was always there. And turning next to the submissions of possibly the counsel of Mr. Blé Goudé, Your Honours, there really should not be any uncertainty vis-à-vis the prosecutor's intention regarding future proceedings. I hope that I'd made that clear in my first round of submissions. But yes, Your Honours, the prosecutor does intend future proceedings. If anything is uncertain, it's only the shape and form of it, which of course will depend as well on the appeal. The remedies of mistrial, as well as a retrial after that, in our mind is perfectly compatible. And of course, we're happy to explain that at a later point in time during the merits appeal. There was some thought about whether the new trial would be particularly onerous. Your Honours, at this point, without getting into any particular details, because we don't have them, it doesn't necessarily have to be so as a matter of principle. There are ways to have a more shorter new trial, possibly even on the existing record. It's just that I'm in no position, nor is the office, to give a commitment at this point in terms of how that might be conducted. And lastly, Your Honours, there was some submissions, of course, on mistrial generally as a remedy. But, Your Honours, I think we'd be very happy to leave that for the merits of the appeal because we believe that it belongs squarely there. Otherwise, that would be it from me. Thank you.
Thank you very much. A private session with the curtains drawn.
Yeah.
Thank you.
We are back in open session, Mr. President.
Thank you. Members of the public, sometimes we have to do these things to have processes in a regular manner. Now we will have received submissions from Council for Côte d'Ivoire, if they have any, to make 5 minutes to react to what was said in response to their submissions for 5 minutes.
Council for Côte d'Ivoire, it is true, yes, we are here as friend of the court. And as far as we are concerned, we are lawyers representing the government of Côte d'Ivoire, and we have a mandate from that government. Now, must a friend of the court be neutral in relation to all the other parties? It would be ridiculous to make such a claim. That would be ridiculous. We are friends of the court and also friends of justice. And initially, there was an application from the government of Côte d'Ivoire requesting our presence here. So perhaps that is the point. Perhaps this is why we are under criticism. Now, secondly, the major point, the major request to make before the court was not to go into procedural matters that basically have to do with the parties, but rather we wish to merely state that we are lawyers representing the government, that is the guarantee of public order in the country, a country that has suffered greatly, that has seen terrible violations of rights, great harm has been done. No one wants those days of violence to return. We all want calm and peace. All we want is for the court to make the wisest decision possible, the most legitimate decision possible. Why would it be that an Ivoirian citizen supporting Mr. Gbagbo or Mr. Blé Goudé, they want to restart the work of reconciliation. The ICC is unique, and they must be able to say that the trial was held, everything was discussed, reviewed, examined, every nook, every cranny of the case was examined, and Mr. Gbagbo was present, and we believe that the conditions were good, humane, and the current conditions are such that they're quite broad. The only restriction is that he cannot make comments on politics. But we are saying that the trial must run to its normal end. Sometimes I understand what opposing counsel has said, and we are entirely cooperative. If new evidence is required, if new witnesses are called, we will cooperate. We want the proceedings to continue with the proper respect for law, and we think that soon, it's much too soon for Mr. Gbagbo to return to his country. The day he returns, and if he is acquitted by you under such conditions, we assure you that the government of Côte d'Ivoire will be the tireless defender of your decision.
Thank you very much, Council. And that brings us to the end of your audience with us, and we thank you. You will now excuse us, and there are some matters the parties would like to discuss. That's some matters that's purely between the parties. So thank you very much for coming, and good luck with your travels back. Now we will go into private session once more, and from private session let's go into at least closed session.
Thank you. We are back in open session, Mr. President.
Merci, Madame la juge, pour votre question.
Mr. Jacobs, thank you for your question, madam.
Comme nous l'argumentions
As
ce matin,
we were arguing this morning, we are of the view that the right to freedom of a person who has been acquitted must be absolute, and that in the absence of justification, for example, new charges or others, the person who has been acquitted must enjoy all fundamental rights: right to freedom, to come and go, the right to liberty of thought and conscience, the right to expression, and all those rights are protected because of the acquittal, which returns to the person or allows the person to enjoy all those fundamental rights. Possible waivers or exemptions must be provided for explicitly, which is not the case in the European Convention of Human Rights. And evoking the theoretical possibility of a waiver in law does not replace a demonstration of the necessity of restriction. As we said this morning, in other words, without concrete, established, justified reasons for the alleged allegations against the person, you cannot provide a waiver to a right on the basis of something hypothetical. Thus, we believe that the rights of Laurent Gbagbo must not be restricted, and he must be in a position to exercise them freely.
Because this morning you have talked about the derogation, the potential derogation of the human rights of Mr. Gbagbo with the decision of this bench of 1st February 2019. But I'm pointing out that the only non-derogable rights, human rights, are pointed out in the Article 4.2 of the International Covenant on Human Rights. The other, that means, unless you sustain another position, that means that other rights, like freedom of free movement or freedom of speech, are not considered under this article, unless that your position is that all human rights are absolute. Please, if you have an answer.
Professor Jacobs. Thank you, Your Honor. To be clearer, the fact that the Convention makes that distinction between a non-derogative right and a derogative right doesn't mean that you can deroge from all rights just because there's a theoretical possibility, just because the Convention says in theory it is possible sometimes to derogate from a right. That doesn't mean you can give free course to a legal authority to allow such a derogation in the case of a person who has been acquitted. We are of the view that there is no justification in human rights jurisprudence or the statute to do so. The fact that this right is not listed amongst the non-derogable rights, that does not take away anything from our position. You need a very strong, solid justification, because this is a human right, a fundamental right recognized by the Convention.
And this tiny question is about, I mean, for you or maybe the OTP will want to answer to this. It's under the legal framework of the Rome Statute, the decisions and judgments of the Appeals Division are meant to be final and certainly creates or trigger a legal or juridical certainty over a case or a matter for the parties and for the international community. The question is your position that the norms of Rome Statute, and specifically their wording, permit the reconsideration of a decision that meant to be final? If yes, please point out which norms, or if any, will be those that permit this reconsideration. Thank you.
Professor Jacobs.
Merci, Madame la juge.
Thank you,
Alors,
Your Honor.
effectivement,
Indeed.
La logique veut qu'une décision
Logic would tell us that a decision that goes through an appellate procedure becomes definitive. That is, the existence of a second level of jurisdiction. There are no provisions in the statute. The Rome Statute does not provide explicitly for reconsideration. This is a legal precedent, or development rather, this possibility of a reconsider that was specifically on this issue of the appeal. We are of the view that in this case, the appellate proceedings on the 1st of February last, as well as the ruling that followed, are de facto a first instance proceeding. Why do we say this? If the appeals chamber had restricted itself to analyzing the reasoning of the trial chamber and identifying within the framework of existing law a number of errors or not, and came to a number of conclusions, then it would have been a conventional appeal with a final decision. But that is not what the appeals chamber did in this case. The appeals chamber took the discussion out of the framework of the trial instance proceedings and outside of the framework of the appeal made by the prosecutor at the time, asking parties and participants during the hearing on the 1st of February a number of questions about entirely new matters. For example, compelling reasons, which is not provided for in the statute. So these are new issues that had never been discussed here at the ICC, that were not even considered by the appeals chamber. So it was a first consideration, and led to what is de facto a first instance decision that was not later subjected.
Mr. Jacobs, so your submission is every time an appeals court asks a question in order to discharge its own function, if that question had not been asked before, that makes that judgment a first instance judgment. Is that your hypothesis?
Professor Jacobs, thank you, Mr. President. No, that is not my hypothesis. I am evoking that hypothesis in the specific case, namely the way that the proceedings unfolded here. The fact that a new issue may come up at appeal does not mean that the appeal is necessarily first instance, but we can agree that here the issue raised by the appeals chamber during the proceedings had not been considered by anyone, had not been considered, viewed, and it was not about Article 80 being interpreted in another manner. The legal framework that we had been asked about during that hearing existed nowhere beforehand, nowhere. Thus, it was not discussed. There was no previous jurisprudence. There was no jurisprudence from other tribunals. It was a first. It was novel. And it was that specific aspect that we thought, because of that specific aspect, we thought that you had handed down a first instance decision.
Just to be clear, so regarding the legal framework of this Rome Statute, you don't find norms to authorize a reconsideration in appeals after an appeals judgment is rendered. Just to be clear. Okay, thank you. I don't know if the prosecution has an intervention.
I can add a few comments. Yes, Your Honor, in principle, a judgment by the appeals chamber, be it under Rule 158 or Article 1, is a final judgment. It's res judicata. That is the principle. Specifically in relation to judgments under 158, what we do have in our jurisprudence is a separate opinion from Judge Pikis in the Katanga case, that is filing number 522 OA3 at paragraph 22, where he specifically refers, and I quote, the finality attached to the appellate process by Rule 158, end of quote. Our position is that in wholly exceptional circumstances, and this is because of the nature of this court, with only one tier of appellate review, there may be instances where the court may have to refer to its inherent powers to prevent an injustice. The test, however, is very high. It should be referred to only in very exceptional circumstances, and definitely not in a situation like this. First, as we said, because there is an other procedure that is available to deal with that matter.
You don't need to repeat the argument you already made.
Very well. So I sit down. Yeah, so I've made my case.
Okay, thank you.
All right. Exceptionally, I understand the counsel for victims wants 5 minutes or so or less. If not, we will leave it at that for the day.
No, Your Honor. Thank you very much for asking, but we don't have any further submission except for saying that if the prosecution is allowed to file by tomorrow noon written submission, then we will ask the same deadline for also our submission in writing. Thank you very much.
All right. Thank you very much, counsel. Then, yes, Mr. Galmeta.
I know I promised the submissions by noon. Can we say 4 o'clock? Tomorrow, 4 o'clock.
All right. Granted, 4 o'clock. And that goes for everyone else. Also, counsel for Gbagbo as well. And that brings us to the close of our proceedings for the day, and we thank everyone for their very helpful submissions. We will look forward to those written filings, and after that, then we will let you know when the judgment will be rendered. All right, thank you very much. Court is adjourned.
All rise, we will leave.